Is that constitutional? Well, if you are asking that question, you're asking a good question. And guess what? About 80 years ago, the Supreme Court might have agreed with you that it wasn't. How are you going to enforce these rules? That's the problem, because what is it going to be, an honor system? They weren't objecting to the presence of that monitor on their ships. They weren't objecting to that. What they were objecting to was being made to pay for it. That's what they didn't want. They're not seizing power for the judiciary. They're giving power to Congress. I don't think it's fair to characterize this decision as a power grab for the judiciary. Given that background, there's a strong argument to be made that it was the right thing to do for the court to overturn Chevron. Well, the Supreme Court's never going to take that case, but they did. This is why we let cases go through the normal appellate process. That's what you were doing. We're sending you to jail. No matter what you think about Trump, January 6th, we have to be very careful about that. Abusing their power to get the results they want. That's the last thing you want, and that's the especially last thing you want the Supreme Court of the United States to be doing. Hello everyone, and welcome back to Straight Down the Middle. I'm Jed Rubenfeld, and today I'm going to be breaking down three different Supreme Court cases. The Chevron case, the Idaho abortion case, and the January 6th Fischer case. And if you stick around to the very end, bonus, I'm going to give you a snapshot overview of the immunity case, the presidential immunity case, which was decided by the Supreme Court literally just 1 hour ago. Okay, we got a lot to talk about, so let's jump right in. So first of all, the Chevron case. Now, normally, when I'm telling you about a case, I start with the facts. What's the case about? And basically, whenever you're thinking about a legal case, that's how you should start. But I'm going to make an exception here. This Chevron case, called Loper-Bright, it involves the power of administrative agencies. And I got to give you some background about administrative agencies in order for you to understand even what the issues are and why everybody's so upset about this case. So, the first question people ask me is, Professor, what is an administrative agency? I just don't understand that. I hear everybody talking about it, but what is it? Well, an administrative agency is simple enough. It's a governmental body, an agency that is in control, has authority over, in charge of some subject matter. Like the EPA is in charge of pollution and other threats to the environment. OSHA is in charge of threats to worker safety and health. Or the FAA in charge of airlines and airline safety. So you've heard of these agencies. I'm sure you've read about them. But the next question you might ask is, well, where do these agencies come from? Are they in the Constitution? No, they are not set forth in the Constitution. They are created by Congress. Congress will pass a statute. We hereby establish the EPA. And here are the things the EPA can do, and here are the things within its authority. So you got a congressional statute that creates the agency and says what it can do and what its authorities are. Well, what can they do? What can these agencies normally do? Well, they can do a lot. They pass regulations. They regulate in the zone of authority that they have. Now, these regulations, they have the force of law. They are law. And the fact of the matter is, because of how little legislation our Congress actually passes, the great bulk of federal law that people have to comply with, it's passed by regulatory agencies, by administrative agencies, not by Congress. Now, you might ask, is that constitutional? Can these agencies pass laws? Professor, I thought only Congress had the power to pass laws. Is that constitutional? Well, if you are asking that question, you're asking a good question. And guess what? About 80 years ago, the Supreme Court might have agreed with you that it wasn't constitutional. A long time ago, the Supreme Court had a doctrine called non-delegation doctrine. And that doctrine said Congress cannot delegate its legislative authority to anybody else. Only Congress can pass laws. It can't pass a statute telling somebody else they can pass laws. That was the non-delegation doctrine. But quite a while ago, back actually in the New Deal, the Supreme Court said, you know what, forget about the non-delegation doctrine. Congress can create these administrative agencies. The world is very complicated. Congress can't expect to know all the details of these technical matters. It doesn't know how to regulate airlines and airplanes for safety. It's okay to create an agency which will have power to do that, and the agency can pass regulations which are actually laws, and we're going to uphold that. So that was the end of the non-delegation doctrine. And the Supreme Court said, yep, these agencies can pass laws. Well, next question you might ask, well, who runs these agencies? Does Congress run the agencies? No, Congress does not run the agencies. Well, who does? The agencies, technically speaking, are located in the executive branch. These are executive agencies. So then the president runs them? Well, in theory, the president has control of all executive officers. So in theory, yeah, he ought to be in control of these agencies. But Congress, in some of these statutes, has restricted his ability to control the agencies. How? How does that work? Well, it's very simple. How does a president control an agency? Well, he gets to appoint the head of the agency, and if he doesn't like what they're doing, he can fire them. That's how a president can exercise control over the agency. So that firing power is very important. He doesn't like what the head of the EPA is doing, gets on the phone and says, well, you better change these policies because I don't like what you're doing. And if the head of the agency doesn't comply, the president can fire them. Except that under a number of the statutes that Congress has passed to create these agencies, Congress has said, not so fast. We're going to protect the head of the agency and make him kind of quasi-independent. We're going to say, Mr. President, you can only fire that agency head for good cause. What does that mean? It's a legal term. I'm not going to get into the complexities, but here's for sure what it means. Simplified, it means the president cannot just fire him at will. Can't say, well, I don't like your policies, I'm firing you. Nope. It's a higher standard before the president can fire him. So that insulates the agency to some extent from federal executive presidential authority. So you might ask, well, how about Congress? Does Congress retain some control over what the agency does? Like if the agency passes a regulation that Congress doesn't like, can Congress veto it? No, it cannot. The Supreme Court has clearly held that Congress cannot, say, by a vote of the House or by a vote of the Senate or by both, just veto an agency regulation. Can't do it. Yes, Congress can pass a law if both the House and the Senate get together, pass a law and get signed by the president. Of course, Congress can always do that. Congressional statute would trump any agency regulation. But nowadays, Congress doesn't do a lot of law passing, and passing legislation is very difficult given our system. So basically, the agency's laws are insulated from congressional review, and they're not fully in control of the president. So these agencies have a lot of authority, a lot of power. And people are worried about that. Some people say it's great. Some people say we're worried about it. But that's your background. Administrative agencies, quasi-independent, tons of power. They can make law, they make policy, they can even adjudicate cases. They can do a lot. Now we get to the case, Loper-Bright. So what's happening in this Loper-Bright case? Okay, these are fishermen. They're herring fishermen in the Atlantic Ocean. They take their fishing boat out, and this agency, the fisheries agency, it's a federal agency, says to them, well, we're going to put some observers on your boat. And on top of that, we're going to make you pay for it. And I know what some of you are saying to yourselves. Maybe you're saying, an agency is telling these fishermen that they have to have a government agent, an observer on those boats? That's so intrusive. Well, there's a very good reason for those observers. Let me tell you what the federal agency would say the reasons are. You got a problem of overfishing. For a long time, foreign vessels especially were coming very close to America, and they were grabbing all of our fish. This is a serious problem, overfishing. Especially with modern fishing technology, you can grab tons and tons of fish. What happens? The price of fish skyrockets after they get cleared out, and there's no more fish. They don't repopulate. You destroy the population. That's called overfishing. I'm sure you all know what I'm talking about. So you had all these foreign seagoing vessels grabbing up all the fish, overfishing very close to American soil. Congress passes a statute. This is decades ago. Congress says, not anymore. We are extending our authority out many more miles, and we're going to pass a bunch of regulations making sure that we don't have this overfishing problem. And we're going to create an agency to oversee this, and it's all going to be better. There's going to be rules about how much fish of all the different species you can harvest, you can fish in any particular season. So we're going to stop overfishing. We're going to keep the fish populations alive. Now, almost everybody thinks this is a great idea, and it has kept our stocks of fish up to a much higher level. And the problem is enforcement. How are you going to enforce these rules? That's the problem, because what is it going to be, an honor system? What if they catch fish out there and then they go off to another port? For that reason, you need observers on the ship. And the original statute passed by Congress empowered the agency to put observers onto the ships. And they monitor to make sure people are abiding by the rules. Now, the fishermen in Loper-Bright, they weren't objecting to the presence of that monitor on their ships. They weren't objecting to that. What they were objecting to was being made to pay for it. That's what they didn't want. They said, okay, we can live with having the observer on the ship. We're going to comply with the rules, but you can't make us pay for it. Now, what was their argument? That the government couldn't make them pay for it. I'll explain it to you. The statute that created this whole fishing agency and all the original rules, it said, yes, the agency can impose monitors, can insist that the ships go out with a monitor, but it said, here are 3 areas where we're going to say that the ship has to pay for those monitors. One of them was for foreign vessels. When they come and they're shipping in American territorial waters, they've got to pay for our monitors. And there's a couple of other areas where American vessels, too, have to pay. Certain zones where the statute says they've got to pay. Now, Loper-Bright's lawyers, they say, well, the statute says that there are these 3 areas where the ship and the ship owners have to pay for the monitors, and we're not in that. We're just herring fishermen in the Atlantic. We're not covered, so we don't have to pay, right? Well, this case goes up to the D.C. Circuit. That's the case. And one of the judges on the D.C. Circuit says, he agrees. He says, yeah, you're right about that. The statute marks out these 3 areas where folks have to pay, and you're not there, so no, you don't have to pay. But 2 judges, they say, hang on a second. We want to ask the agency, the National Marine Fishing Service, we want to ask them, what do you think the statute means? And they said, well, we're the ones who are asking them to pay. We think it means that we get to pay. And the court says, yeah, well, just explain it to us a little bit. They said, well, the original statute, they were requiring payment just in a few areas. They allowed us, the Marine Fishing Service, to make our own rules for the Atlantic. They didn't say we couldn't make vessels pay when we're making our own rules. They were just given the rules for those other areas. They never said we couldn't make them pay for the monitors, and we're just copying what they did in the other areas. 2 judges on the D.C. Circuit said, sorry, that's it. Our hands are tied. Loper Bright said, well, what do you mean your hands are tied? And the 2 judges say, Chevron. Well, what's Chevron? Chevron was a case decided by the Supreme Court 40 years ago, saying that when an agency has interpreted the statute that it's operating under, courts have to defer to the agency's interpretation of that statute, as long as there was some ambiguity in the original statute. If the statute's clear, then it's clear, no problems. But if there's any room for disagreement, if there's a bunch of different possible interpretations, the courts are not permitted to cast aside the agency's interpretation. The agency's interpretation wins. Courts have to defer to it. That's the Chevron case, the famous Chevron case. Well, this case goes up to the Supreme Court, and the Supreme Court says, sorry, we're overruling Chevron. And that's what everybody's talking about. The court's overruling Chevron. How can it do that? Well, let me give you the arguments in favor of Chevron. The big argument is, hey, only these agencies have the expertise. Courts don't have it. Courts don't know half the stuff, 3/4 of the stuff that agencies do, and they can't possibly review it. You got to leave it up to the agencies. One of the dissenting justices, Justice Kagan, in her opinion, she gives a very good example. She says, just, to take one random example, under one of the biological use statutes, an agency has to decide what a protein is. And the agency has interpreted the word protein to mean a molecule with a bunch of amino acids and certain acids in a certain sequence. She says, courts can't possibly review that. What do we know? That's why we have Chevron, because you got to defer to the expertise of the agency. Okay, now what's the argument on the other side? What does the Loper Bright majority say when they're overturning Chevron? They say, well, 2 things. First of all, by a long tradition in this country, courts are the bodies that interpret statutes. Indeed, under the Constitution, the judicial authority, the judicial power, is vested in courts. And the judicial power, well, that's the power to say what the law means. That's the power to interpret statutes. And so just by tradition and constitutional tradition, courts should be doing statutory interpretation, not agencies. But the majority has another argument to make, and it says, and look at the Administrative Procedure Act. That's this big act passed by Congress that governs all agency procedures and proceedings. And the Administrative Procedure Act specifically says that courts should be reviewing and adjudicating legal issues. And the Loper Bright majority says, look at that. That's in the statute itself, and it tells us that we, the courts, are supposed to be doing the statutory interpretation, not the agency. Now, that second argument about what the Administrative Procedure Act says, that's very important. I'm going to come back to that in a minute. I'm mentioning it to you because it's so important, and I'll tell you why in just a minute. Now, what does Justice Kagan say in response to these arguments? Justice Kagan says, I'll tell you what's really going on here. This is a power grab by the judiciary. This court is cutting down the powers of agencies and arrogating, grasping for power itself. Now, Justice Kagan, old friend of mine, she's one of the smartest justices, in my opinion, who's ever sat on the Supreme Court. But straight down the middle says she overreached on that one. And let me tell you exactly why. This is the key issue. This is what everybody's upset about. Should agencies have more power, or should the agency's power be restricted? And is the court grasping power for itself? The folks who are criticizing Loper Bright, they're agreeing with Justice Kagan on this point. But here's the problem in Justice Kagan's statement about the court grasping power for itself. What the court says, you look at the majority opinion carefully, what they're saying is, if Congress passes a statute and says, we're creating this agency, and the agency gets to interpret the statute, the terms of this statute, the majority opinion says, we're going to uphold that. It's up to Congress. Remember, we told you that the Administrative Procedure Act gives us, the courts, the power to interpret statutes. Well, if Congress wants to change that for some particular agency, some particular statute, it can do it. It can give the agency the power to be the statutory interpreter, and we will uphold that. And the court gives some examples where Congress has done that, and the court says we have no problem with it. That's the majority. This is very important. The concurrence says, no, that would be unconstitutional. Strongly suggests no, only courts can do statutory interpretation. But the majority says, no, if Congress passes a statute, says, agency, you get to interpret the statute, then says the majority will uphold that. And see, that's very important, because what that means is the Loper-Bright majority, they're not seizing power for the judiciary, they're giving power to Congress. They're saying to Congress, hey, it's up to you. So what the Supreme Court's been doing over the last few years is actually trying to impose some checks on agency power, trying to give the president a little more power over the agencies, and here in this decision, giving Congress the ultimate power over the agencies. And if Congress wants, it can give agencies more power if that's Congress's choice. So I don't think it's fair to characterize this decision as a power grab for the judiciary. It's up to Congress. They can decide. So let me close with respect to this case, Loper-Bright, with the following remarks. Basically, the issue with these agencies is who's going to check them? How do you have the checks and balances that the Constitution stands for apply to these agencies? We've lived with them for a long time with limited congressional power over them, limited presidential power over them, and under Chevron, limited judicial power over them. So given that background, there's a strong argument to be made that it was the right thing to do for the court to overturn Chevron and to overturn it the way it did. First, it allows the judiciary to be a check on regulatory administrative agency interpretations of their own statute. If they overreach, the judiciary can be there to put a check on them. At the same time, what the court did was it said Congress can be a check. It's going to be up to Congress to decide how much power they have. Given that context, I think there's a strong argument to be made for overturning Chevron. And I got to tell you one other thing. Even though you might have heard a lot of people getting very upset about overturning Chevron, the fact is Chevron had been chipped away at for a long time, and it's not even clear how much vitality Chevron had and how often it was actually enforced. The Supreme Court itself had not upheld an agency interpretation of a statute under Chevron for 10 years. So my guess is this overturning of Chevron will have less of an effect than people are suggesting, but to the extent it has an effect, there's a strong argument to be made that it was a good move in terms of restoring checks and balances against relatively independent federal agencies which were exercising a ton of power but were not accountable to any voters and less accountable than maybe they should have been to the executive and to the legislature and to the judiciary. Okay, that's what I wanted you to know about Loper-Bright. Now you understand the Chevron issues, so we're going to move on. Let's talk now about the Idaho abortion case. Now, this kind of may have flown under the radar a little bit. If you saw headlines about it, you might have been confused. What exactly did the court hold? What didn't it hold? Here's what you need to know about that case. The court was simply correcting a mistake that it had itself made earlier in these proceedings. It didn't make new law. It kicked the case back to the lower courts, correcting an overreach of its own. Let me explain to you exactly what happened. What's going on in this Idaho abortion case, Idaho versus the United States? Well, Idaho has passed a statute strictly limiting abortions to something like 6 weeks. Only exception if the abortion is necessary to save the life of the mother. But there's a federal statute that says emergency rooms at hospitals, hang on, they have to perform any medically necessary procedure when it's needed for the health of the patient. Not necessarily if they're going to die, if it's needed for the health of the patient. They have to. And a federal judge out in Idaho, he had said, well, federal law trumps state law. So emergency rooms in Idaho hospitals, they've got to comply with the federal law. They have to perform abortions if it's necessary for the health, to preserve the health of the mother, even if the mother is not in imminent danger of dying. So it's going to be more expansive, and it's going to overrule the Idaho law. The federal court issued an injunction saying the Idaho law cannot be enforced against hospitals that are performing abortions in their emergency rooms when necessary to preserve the health of the mother. Now, the lawyers for Idaho, they petitioned to the Supreme Court of the United States to hear that case. That's very unusual. Normally, a case has to go through an appellate process before it gets to the Supreme Court. You can't just go from the district court to the Supreme Court, almost unheard of. And so when many of us read that Idaho was trying to jump over the circuit court and go right to the Supreme Court, we said, well, the Supreme Court's never going to take that case, but they did. They reached out, and that takes a vote of at least 4 justices. They reached out and said, yeah, we're going to take that case. And it looked like justices who were hostile to abortion were changing their own normal rules to take this case. It looked like they were going to overrule that injunction and say, no, that Idaho law, that gets to be enforced. The judge was wrong. The federal law doesn't mean what the federal judge said, and it's the Idaho law that's going to trump. So the Supreme Court took the case. And just recently, last week, the court issued its ruling in the case. And it was a 1-paragraph ruling saying, we made a mistake. We should not have granted cert. That's all it said. And then there were a number of concurring opinions. And from the concurring opinions, you could kind of get a glimpse of what was happening behind the scenes. 3 justices, they said, that judge was wrong. We did not make a mistake. We should be reversing that judge. We were right to take cert and we should reverse. 3 justices said, more or less, I'm simplifying, the judge was right. We should basically affirm. But 3 justices, in an opinion written by Justice Barrett, she said, we made a mistake. It came out at oral argument. We're not even clear how the Idaho statute is being interpreted. Idaho says, actually, it permits abortions when necessary to preserve the health of the mother, even if the mother is not in imminent risk of death. The exception is much wider than the lower court, the district court, thought. And the government said, no, that's not true. And Justice Barrett said, this is why we let cases go through the normal appellate process. This is the kind of thing that has to be worked out below. By the time it gets to us, we should be clear what the issues are. There should not be a debate about what the laws mean. It's up to us to say what's constitutional. We don't want to dispute about what Idaho law means. Once we know what Idaho law means, we'll tell you if it's constitutional. But that's not for us to decide what Idaho law means. And that's why we have cases go through a normal appellate process, so the meaning of these state statutes gets clarified before it comes to us. We made a mistake. We're kicking it back to go through the ordinary appellate process before it comes to us. Now, I think that's a good move by the Supreme Court. Let me tell you why. Whatever your views on abortion are, and of course that's a very divisive issue, because it's so divisive, because it's so controversial, you do not want the Supreme Court changing its rules in the middle of the game. That's the worst thing that we can do. When we've got these incredibly divisive, partisan issues that everybody's disagreeing about, what you want is a judicial system, and for that matter, you want all organs of government to play by the rules, not to change the rules in the middle so it looks like they're abusing their power to get the results they want. That's the last thing you want, and that's the especially last thing you want the Supreme Court of the United States to be doing. So, I'm in favor of this remand. It didn't make any new law. Bottom line, for now, that district court injunction remains in effect. Emergency abortions can be performed in Idaho, and we'll see what the appellate process says. No new law was made, and now you understand what happened in that case and what the issues are. And on that point of changing rules in the middle of the game, that brings me to the last case I'm going to discuss in depth with you today, and that's the Fischer case. That's a January 6th prosecution. And the Supreme Court issued a very important ruling in that case about what January 6th defendants, these people who entered the Capitol on January 6th, what they can be charged with and what they can't be charged with. Okay, let's jump right in. What's at issue in this Fischer case? Well, Fischer, he's one of the people who went into the Capitol on January 6th, and he was charged by the prosecutor in that case with a violation of 18 U.S.C. section 1512. Now, what does that statute say? It makes it a criminal offense to alter, mutilate, destroy, or conceal a document or a record or another object to obstruct an official proceeding. And then it says, or to otherwise obstruct an official proceeding. Believe it or not, this whole case turns on the meaning of the word otherwise. That's how the law works. That one word in the statute, otherwise, that's what's causing all the confusion. Because the prosecutors are saying, okay, he didn't alter or mutilate or destroy or conceal a document. No, we're not alleging he did that. We're alleging that he was trying to obstruct an official proceeding. What official proceeding? Well, Congress was getting together in the Capitol on that day, January 6th, to count the electoral votes. That's what happens on that day. And the folks who went into the Capitol, according to the prosecutors, they're trying to obstruct that official proceeding. Now, Fischer's lawyers, they say, well, what are you talking about? This statute was obviously aimed at tampering with documents. That's what it says. And they point out correctly that the statute was passed as part of the Sarbanes-Oxley Act. It was passed in response to the Enron scandal some years ago, where it was at least alleged that executives, officers at Enron destroyed a lot of documents in order so that those documents wouldn't be used in the prosecutions against them to show their guilt. And there was no federal statute at the time that specifically addressed that. So Congress passed a statute saying, hey, you cannot be destroying or altering or concealing documents that are going to be used in a trial against you in an official proceeding. If you do that, that's a serious penalty. Now, Fischer's lawyers said, well, we're looking at all the past cases, and we don't see that anybody has ever been charged under this statute who did not forge a document, alter a document, destroy a document, conceal a document. They were all document tampering cases, but you're now using them against us. Now, I can't vouch for this, haven't done the study myself, but I have seen that some people say that what the Fischer defendant was saying was correct, that this statute has not in the past ever been used against defendants except in document tampering cases. And if that's true, that's a very important point. and I will come back to it. But anyway, they're saying under the statute is only there for document tampering cases. And what does the prosecutor say? The prosecutor says, no. Look at the word otherwise. It says otherwise. It says otherwise obstruct an official proceeding. That's what you were doing. We're sending you to jail. So this case goes to the D.C. Circuit. And what does the D.C. Circuit say? D.C. Circuit splits. One judge, Judge Pan, he says the words otherwise, the statute says it, if you otherwise obstruct a proceeding, otherwise obstruct can be through other means. It doesn't have to be through document tampering. What are you talking about? The charge is perfectly fine. Another judge, Judge Katz, he says, no, this charge isn't fine. This is about document tampering and altering and mutilating. And if you're not doing any of those things, you can't be prosecuted under this statute. So the D.C. Circuit splits, goes to the Supreme Court, and we get two very different opinions. The dissenters, they agree with Judge Pan. And they say, well, otherwise means otherwise. And you can prosecute anybody for obstructing an official proceeding. Where's the problem? But the majority, they pick up on Judge Katz's ruling. They say, no, Katz was right. This statute can only be applied in cases where somebody is altering or forging or doing something with a document or a record or another object, and in that way obstructing an official proceeding. And the word otherwise has to be understood to mean other things that are similar to that. Okay, so that's the majority opinion, and now you know the dissenting opinion. So what are we supposed to make of this? Well, if you've been following my appearances, you may know that I predicted exactly this outcome in the case. I said there was reasonable arguments to be made on both sides, and you would see some justices taking one side, some justices taking the other. It's interesting that it does not, this case, break down on ideological lines. I was glad to see that. You've got Justice Jackson joining the majority. You've got Justice Barrett joining the dissenters, and that's a good thing for the country. What's the strongest argument on the side of the dissent? The dissent says, plain meaning. The statute says if you alter a document or otherwise obstruct an official proceeding, you're guilty. Where's the problem? The strongest argument for the dissent is they've got the plain meaning of the statute on their side. What is the majority's strongest argument? Actually, I think the majority's strongest argument has to do with the whole Sarbanes-Oxley statute. Let me explain it to you in very simple terms. The majority makes this argument, and here's what they say, and I think it's a pretty good argument. They say, the Sarbanes-Oxley Act, this isn't the only obstruction of an official proceeding provision. Are you kidding me? There's numerous such provisions in this statute. There's a provision saying that if you tamper with a witness to obstruct an official proceeding, that's a crime. If you beat somebody up so that they won't be present at the official proceeding and in that way obstruct an official proceeding, that's a crime. If you harass somebody with the intent of getting them not to appear at the official proceeding and in that way try to obstruct an official proceeding, that's also a crime. There's all these different ways that the statute says that makes it illegal to obstruct an official proceeding. Here's what's interesting. Some of them are less serious than others. So that harassment provision that I just mentioned, that's a 3-year crime under the statute, whereas beating somebody up, 30-year crime under the statute. Now the Sarbanes-Oxley provision that's at issue here, tampering with documents, 20-year crime. But think about this. If you take that word otherwise from this provision and say that all acts of obstruction are covered by this provision, you wipe out all the other provisions in the statute. You got this statute that lays out all these different ways of obstructing a proceeding, some more serious than others, and then suddenly you stick in this one last one about tampering with documents, a term that says, no, all obstructions of a proceeding, they're criminal under this statute, and they're all 20-year penalties. Well, what happened to all the other ones? You just wipe them all out. The whole statute's useless. You can just the prosecutor can always go under this provision, even when somebody just harassed somebody else to obstruct a proceeding. Well, he also violated this provision. He can get the 20-year penalty. Now, why did the prosecutors want to use this statute that's complicated and subject to differing interpretations? Well, I've just given you the answer, because it's a 20-year penalty. That's why the prosecutors are using it in the January 6th cases. Let me be very clear about that. A lot of these people who went into the Capitol, if the prosecutor can't get them for this Sarbanes-Oxley violation, the only thing they got him for is like trespassing on government property. That's a misdemeanor. That's nothing. So the prosecutors have been using this charge under this statute, 1512, in hundreds of the January 6th cases. That's a 20-year penalty. Judges have been sentencing them to years in jail. Many of the defendants have been pleading guilty because of the threat of a 20-year prison sentence. And the Supreme Court majority says, nope, can't do it. That's an improper overreach and extension of what the statute means. We're not going to allow it. Now, here's what I'm going to say about it. I've given you arguments on both sides, but what I don't like about this situation is you've got prosecutors using a criminal statute in a new way in arguably a very highly politically charged environment. And you know that this charge, the same charge, violation of Section 1512, that's been charged against former President Trump as well. So this case, Fischer, is very important because it strongly suggests that 2 of the 4 charges in the January 6th case against President Trump, former President Trump, are also no good under the Fischer ruling. By the way, it's not 100% clear that's true. Prosecutors say, no, there were documents and records that they were forging and changing in that case. So our prosecution against Trump under this very same statute is still going to stand even after the Fischer ruling. But what I'm not crazy about is criminal statutes being used in a new way when prosecutors appointed by one party are going after people from another party. No matter what you think about Trump, January 6th, we have to be very careful about that. You cannot allow the criminal justice system to be used in brand new ways to go after political enemies. At least we should be very careful. It's important for the Supreme Court to exercise review and make decisions about when those new interpretations have gone too far. So maybe that's the very best argument in favor of the Fischer case. We should not allow the Justice Department to change its rules in the middle of the game any more than we should want the Supreme Court to change its rules in the middle of the game. We don't want any of our governmental entities changing their rules in the middle of the game when it's convenient to do so to go after political enemies. Okay, that's all I'm going to say about those three cases, but now for the bonus round, I'm going to give you a little snapshot overview of the immunity case that just came down an hour and a half ago. Now, I predicted the outcome of this case too. If you've been following my appearances, I told you this is how the case was going to come out. I haven't read all the opinions yet, so I'm just giving you the overview. The Supreme Court did not decide that Trump is immune from all prosecution, did not decide he's not immune. No, the Supreme Court did was it laid out a new standard of presidential immunity and kicked the case back to the lower courts to apply that. And let me give you the background so you'll understand what happened. Well, in this case, the prosecutor was saying there's no such thing as presidential immunity. Once a president's out of office, we can come after him for any criminal offense. There's no presidential immunity protecting former presidents. And what were President Trump's lawyers saying? Trump's lawyers were saying the opposite. Anything done by the president during his time in office, fully immune, you can't touch him. So you had two very extreme positions being taken by the two sides. That often happens in litigation. And the D.C. Circuit, they had adopted one of those extreme positions. They had accepted the government's position. They had said, nope, there's no such thing as presidential immunity. Once the president's out of office, he's not president anymore. He's just Mr. Trump. He's a former president. There's no immunity, period. As predicted, the Supreme Court said, that's going too far. We think there is and has to be some immunity for some acts taken by the president that you can't prosecute them for even after they leave office. Basically, the Supreme Court's saying, first of all, you got to divide between official acts and unofficial acts. Unofficial acts, president does something that's not an exercise of one of his powers, there's no immunity there at all. For official acts, the Supreme Court says, hey, if it's within the core of the president's constitutional powers, that's total immunity. If it's not in that core, then there's going to be something the Supreme Court is now calling presumptive immunity. In other words, the president, former president's, going to be presumed to be immune, but the government can rebut that presumption. And the court says some things about how the prosecutor would have to rebut that presumption. And in another episode, I can explain to you in more detail about exactly what the Supreme Court held and what it didn't hold. But here's what you need to know. The Supreme Court creates this new standard, kicks the case back to the lower court, says now you got to decide there's a bunch of issues that come up now that we've told you what the standard is. For a lot of these acts that Trump is charged with, you got to decide was it official or unofficial. And if it was unofficial, he's not immune at all. If some of these acts were part of his official exercise of power, then you've got to decide how this new presumptive immunity plays out. Is this a case where his presumptive immunity controls, or can the prosecutor rebut that presumption of immunity? So, case is kicked back. That means you're not going to see a trial of this case before the election, but instead, it'll have to go through the normal appellate process. And that's what I've been trying to tell you. That's okay. It's okay for these cases to go through the appropriate normal process. You should not object to that. That's how we want the system to work. And that's all the Supreme Court has done right now. It's articulated a new standard, kicked it back to the lower courts to apply that standard, and we'll have to see what they say. So let me close with this. It's so important in our system to have checks and balances and to have the various players stay within the rules of the game, not to change those rules when it's convenient to do so to achieve the objectives they want. In a number of the cases that I've tried to describe to you today, you've seen those issues arising, and I've done what I always try to do with you. I try to present those issues straight down the middle, giving you the arguments on both sides so you can make up your own mind. Well, I hope you understand those issues better, and stay tuned for more episodes about this very important Supreme Court term. Bye for now.